So right there, this duct tape solution to avoid probate is going to end up costing those kids $45,000. $45,000 that they wouldn't have otherwise had to pay. Hi, Jeff Marsachi, the Plain English Attorney, and this will probably be a bit of a shorter video, but we're going to talk about capital gains taxes and joint property, and this is just another example of how these duct tape solutions just come out not working well in the long run. As I've said in other videos and in blogs, these duct tape solutions of, oh, well, I can just do this little thing and it's going to accomplish this great estate planning goal or this Medicaid planning goal, they often end up blowing up in the long run. And unfortunately, sometimes the people who did the planning are not around to actually see it blow up, and now their family just says, well, why on earth did mom or dad or this person do that? So let's go ahead and jump in with just a couple of things at the beginning. When we talk about estate planning, and avoiding probate becomes a big deal for a lot of my clients and for a lot of people in general. They just don't want to have the court involved in administering their estate if it doesn't have to be there, because it's expensive, it's time consuming, it opens things up to the public, and it just takes a long time, and people get frustrated with it, and they don't want to have to deal with a court. So I often hear, well, all right, well, I've got my house. I'm just going to put my 3 kids' names on my deed, and that's it. All set. Avoid probate. Yeah, but there are a lot of drawbacks to that. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. One of them is, well, what if one of your kids gets sued? Your house could be on the chopping block for that because it's not protected for you. Okay, what else is there? Well, what happens if one of your kids passes on before you do? Oh, well, that's not going to happen. Well, look, it happens more than we'd like to think. And unless you've got a 100% accurate crystal ball, it's not going to work. So well, then what happens if you've got your 3 kids on the deed to your house and one of them passes on? Well, I would want it to go to my deceased child's kids, meaning my grandkids. Nope. Just goes to the other 2 kids. All right. What if the kids are actually young at this point? Well, okay, well, I'd want a trustee to oversee. Doesn't work. Well, I can put in my will that anything that, is going to my beneficiaries, there's an age limit. Nope. It avoided probate, so the will does not cover it. And we'll specifically link a video that I've called But the Will Says, and why it doesn't govern stuff like this, because the idea is avoid probate. Having a will means it's going into probate. If something doesn't go into probate, it doesn't follow the rules of the will. So the big money thing is capital gains taxes. Now let me explain just a little bit. When someone passes on in the U.S., there's an estate tax. Everything you own or had control of gets examined for estate taxes. Does it reach the threshold? And right now we're in 2023. That threshold is $12.96 million. I've got some clients where that could be an issue. Most of my clients, it's not an issue. All right, so that examination, though, comes with a benefit. And the benefit is whatever interest you had, your cost basis gets bumped up to fair market value at the date of death. All right, so if you owned a house for $100,000, it's now worth $500,000 when you pass on. The kids sell the house for $500,000, no capital gains taxes. Okay, well, that's a good tax benefit. All right, well, when you do joint property, you're messing that up. So let's jump over to some slides that I put together to explain this process in a little more detail. So if dad, single dad, originally purchased a house for $100,000, and later he's seeing this stuff about joint property and with the right of survivorship, it avoids probate. Oh, that's what I want to do. I want to avoid probate for my estate. Let's put the kids' names on the house so they can inherit the house without probate. And that is what would happen. 20 years later, dad passes on, and the house is now worth $500,000. Well, the children don't want to keep the house, so they sell it. What amount is subject to capital gains taxes? So when you're putting the kids on the deed like that, they're getting a percentage ownership. But that percentage ownership comes with that same equivalent percentage of cost basis. So now, again, overall, the original cost basis was $100,000 because that's what dad purchased it at. And so we split that among the 4 owners now. So dad and each of the kids, they each have $25,000 of that cost basis. Okay, what does that mean now? After dad passes on and we get that bump up in cost basis, it's called a stepped up cost basis. Well, that only applies to the quarter that dad owned. So his cost basis bumps up to $125,000. But each of the kids' cost basis, because they didn't pass on, that remains at $25,000 each. And now what's subject to capital gains taxes? You take the full $500,000 fair market value and you minus out the cost basis. So that's going to be $125,000 for dad, $25,000 for each child. That's $200,000. So there's $300,000 worth of gain subject to capital gains taxes. So at the 15% rate, that's $45,000 of capital gains taxes. So right there, this duct tape solution to avoid probate is going to end up costing those kids $45,000. $45,000 that they wouldn't have otherwise had to pay if they had just inherited the house in some fashion. And if you want to avoid probate, if you set up a revocable living trust, it could own the house, get the full stepped up cost basis, and then go to the kids without those capital gains taxes. And let me interject here because I hear this all the time. Well, wait a minute. Don't you get the $250,000 exclusion? So these kids shouldn't be paying any capital gains tax. No, that exclusion is only if you've lived in the property for 2 years. So if they haven't actually lived with dad for 2 years, they're not going to get that exclusion because it wasn't their primary residence. You only get that credit on your primary residence. You want the details, talk to an accountant. But look, most of the time when we're talking about these situations, a parent is putting their kids on the deed and they're not living there. And so they are going to end up with those capital gains taxes. So this is why these duct tape solutions have a lot of drawbacks that people just don't see when they're originally looking into it and trying to figure out what should I do. They have a really good goal of avoiding probate for their estate, but they're doing it in a way that's going to end up having a lot of drawbacks. So please go ahead and check the description. We've got a lot of free resources. Basically, I'm a law firm, but really I think of myself as an education company so that we can provide you this information on these important topics. And if that means you want to come in and do business with us and you're residing in North Carolina, great. Right. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, Make it a great day.